So let's say you have your podcast, which I guess that's a service that you're providing.
Why'd you roll your eyes?
Well, I'm thinking, I guess that's a service.
Okay.
Yeah, I mean, it's not a good recording.
This is valuable content. This is valuable content that people need to know.
You're welcome, the world.
Yeah.
Hey, this is Chaz Roberts. I'm a personal injury lawyer. It's my passion to bring the law to the people, and that's the purpose of this podcast. You're listening to Law Have Mercy.
Dude, do you want to spice up?
You are listening to Law Have Mercy.
Sarah has a really funny story.
Which one? Which one?
Sarah?
Which
All right,
one?
so Sarah and Ben go to one of the most prestigious places in the country. It was in Idaho.
Yes.
Okay. And it was a nice resort.
Mm-hmm.
And her last name is Dupont.
Oh, yeah. Okay.
Which happens to be one of the most wealthiest families in the country, if not the world. And Sarah didn't take the time to say, no, not those Duponts.
Well, apparently it's also, there's also a famous or like Olympic skier with that last name too, who was from Sun Valley, Idaho, where we were, and they thought that I was somehow related to them. I was like, I mean, I didn't tell them otherwise.
Of course not.
But no, I'm not a skier. So.
Here's an extra towel for your swimming session today.
Miss Dupont.
So on today's episode, I am selfishly, I've been looking forward to for a long time because I'm trying to get some legal advice. You're going to tell us all about how to protect our brand, right? And I have a brand and I want to pitch it to you and I want to know how I'm going to protect it. So today's guest, Sarah Dupont, she is an intellectual property lawyer. What that means basically is she helps with trademarks, patents, all that good stuff, right?
Right.
Did I get that right?
Yes.
What else do you do?
We also can help if there's a separate little subsection of intellectual property that we can talk about later. When you get into trade secrets as well. So it's not necessarily something you would want to register or put out there, but we also handle a lot of trade secret litigation, which is really popular now, especially for, former employees leaving companies and things like that may have taken some things or things of that sort. So we handle that kind of stuff too.
Sarah, I hear your neighbor's a real ass.
Yeah, he can be.
Is that true? We live across the street from each other.
We're neighbors, and our kids play together all the time. Actually, my son's there right now. So, it's been great. It's the end of school now. So, Sarah, I guess you keep the kids sometimes during the week? Actually, Tucker was at my office this morning trying to get some things done. And then, so, I mean, I'm fortunate to have a very flexible schedule. And with what I do, we can kind of move around and be flexible. There's a lot of things that are coming up down the road, so you can plan around it. So it works out well.
What's it like being a busy mom? Because my wife doesn't work, and so she has a full-time job taking care of the kids, getting stuff for school, keeping the house in order. How is it being a professional lawyer that's doing very busy, meaningful work, and being a mother of 2 children?
It's a lot, but I mean, I really don't know any different. I never really get a break, but I wouldn't have it any other way. So, kids are at school, I'm doing my day-to-day job. Kids are off school, I go pick them up, and then I'm doing my mom job. And, I just think being able to have both of those, it's really nice because, while I do like to stay busy, and I do stay busy, you get a break from each one. So, like when I'm at work, I try to be at work unless you get a phone call or something from school. But
Nurse Claudia.
Right, Nurse Claudia emails. But then when I'm at home, I really try and just be at home. And I really, unless we have something that's really pending or, coming up soon, I'm really trying not to bring work home if I can help it. So, and just being extremely organized. It really also helps.
I struggle with that. If I take out my laptop at home, it's over. I'm completely focused in on that. I take away from my family. I really try to keep the laptop closed.
Yeah, and the emails, I mean, people expect almost immediate responses, and I try not to do that. I mean, I'm going to wait and respond in the morning. So, I think just in general with lawyers, people do expect that, and because they know we have our phones and we can see our emails. But, I try and respect, my time at home if I can.
My paralegal, Sasha, always guides me and says, Chaz, you cannot create an unrealistic expectation of responding to emails too quickly, because then they're always going to respond.
Right.
And think that if you don't respond within an hour, you're ignoring them
right.
if that's what you typically do. So you need to really keep that 24-hour rule in play. Respond within 24 hours, perfectly reasonable.
Yeah, absolutely.
Or if even over the weekend, respond on Monday.
Yeah, I mean, if it's an urgent thing, I understand, and you can kind of look at them and sift through them and see, but a lot of times it's not. It might be urgent on their end, or they created the urgency because they got to you last minute. It
happens.
Yeah.
I've had a lot of clients that have come to me and asked me for advice and say, look, I created a t-shirt brand. I've actually created a brand called Sandy Lies because
shameless plug.
Shameless plug. Well, it was humming till COVID came and we realized we couldn't get any caps.
Yeah.
But the idea is that we came up with a concept of a brand. All right. And so when people pitch me their brands, they ask me for legal help. And of course I say, I don't know anything about that. I just handle personal injury cases.
Yeah.
How does somebody go from having a concept of a brand to actually being able to protect their brand?
So when you think of a brand, what people are generally thinking of and what it relates to in the law is a trademark. And a trademark, we use the word trademark, but it really can cover both goods and services that you are looking to identify with your business. So there's specifically trademark covers if you provide a certain good. So your hats, for example. And then if you have a service, it's called a service mark. But we use trademark kind of interchangeably for both. So that's what people associate with this type of law. Covering or trying to protect the brand. You're creating a brand. So you think of the name, and then maybe you think of a certain logo that you might want to go with it. Well, then you're also talking about your business and its reputation and its goodwill that it has too. So all of those things go towards your brand. So when you're looking at or wanting to know about protecting that, the first thing that actually you do, which seems a little counterintuitive, is you use it. That's the first thing when you're wanting to protect your brand or talk about a trademark or something like that, is you actually use the name or the mark. That's what we call it. It's a term of art. The mark, logo, whatever it is. You use it in commerce. So, okay, well, what does that mean? Well, you start marketing your brand, you start selling your hats, you get them into production, you make them available for sale, whether it be online or in a retail store, whatever that is. You start actually using it. Now, you may need to do a little due diligence first. If it's kind of a common name, you might want to look and see if there's something similar out there before you put all this time and effort and money into creating it. So there is a little bit of that involved too, but
how do you look up a name to make sure it's not already being used? So
you can do it a few different ways. You can do it through just the Secretary of State in your specific state. So like here in Louisiana, we have a Secretary of State database, and you can look up and you'll see if there's actually a business name that has that, and then two, you can also see if there are specific trademarks on it too that are registered at the state level. If you want to go beyond your actual state and you think, okay, I may sell these online, it could be endless, or I want to go into Texas, you can go on to United States Patent and Trademark Office. We call it the USPTO. So they have a database, and you can go on and kind of do a basic word search to see if there is, the name, of your company or your brand that you want to create, and see if that's already registered. So now that's not, it doesn't necessarily cover everything, because there may be other companies or names out there that are unregistered but are still using it. And we can talk about that and the difference of that here in a little bit. But it just kind of gives you an idea of what, if any, brands or names are already out there and taken. So it's kind of important to do that first before, again, you do spend time and money and effort into creating something. And then you realize after you've made your hats, you're like, oh, shoot, you know, somebody has this. And,
I knew that was a good name.
Oh, yeah. Somebody else liked it too. But then you actually use it. So that's really the first step into establishing your rights with your mark, your logo, your brand name, and all of that is you use it in commerce.
That is counterintuitive because some people would think I have this genius idea. I need to call a lawyer immediately. No, you actually have to do a preliminary search, make sure there's nothing else out there like it, and start actually using it.
And it's the same thing with attempting to register it too. So whenever you go to register a trademark, they're going to ask you, one of the requirements in your application is the date that you first started using it. And so you have to use it first before you even register it too. And it's different in like the patent context when you invented a new invention and you think, okay, I want to get a patent on this. Well, for that, in that instance, we recommend you file an application first before you then release it to the public for various reasons. But yeah, in the trademark world, it's actually the opposite. You got to start using it first before you can register it.
And then what's the registration process look like? I'm sorry, let's back up. First you use it.
First you use it.
And conduct your search that it's not already in use, because if you start using it and someone else has it being used, they can file something against you.
Correct.
They can cease and desist.
You'll probably get a letter first saying, oh, no. we have this mark. We've already been using this. It's for the same and similar type of goods or services, because that's another important aspect of it too. You can have a name that you associate with your brand and your goods and your services, but if a competing company is using that same name in a different arena, then it's not a violation. So a good example of that is you think of the name or the brand Delta. Well, Delta Airlines. Well, so they're in airline services and all of that. Well, there's also Delta associated with, like faucets and hardware and kitchen appliances and things like that.
We're currently undergoing a renovation.
So you know all too well about that.
So I know about Kohler and Delta and too many other expensive faucets.
So that's a good one where you think, okay, they both have name recognition and brand recognition associated with that name, but they're both able to have that because it's in two different types of goods or services that they provide. So your name, your brand, your mark, it ties to your identification of goods or services that you are providing. So
Sandy Lies would be an example of a product. Would Law Have Mercy? Here's my second pitch. Law Have Mercy. Would that be the service?
Well, so if, for example,
I'm not selling these mugs, by the way. Maybe I am selling these mugs. Can we get a merch shop up?
And you can have one for, like, you can have your mark be with different types of goods, and so you can register it for different types of goods. So let's say you have your podcast, which I guess that's a service that you're providing, and then you also.
Why'd you roll your eyes?
Well, I'm thinking. I guess that's a service.
Okay.
Yeah, I mean, it's not a good. Recording.
This is valuable. This is valuable content that the people need to know.
You're welcome to the world.
Yeah. And then, but then if you go into like apparel and, these types of goods too, you can also register, your mark or your phrase, Law Have Mercy, assuming it's available, associated with goods that you can sell to, like retail merchandise as well.
What about a logo? Like my law firm logo, I can register that?
Yeah. Is it registered now?
No. Is that a problem?
No.
Okay.
No, because you're using it. So really, if you see somebody else has a similar logo,
of course it's registered. If you're listening out there, don't come try to snipe me.
If you see that somebody else is using the same kind of CR, I don't know what those lines are, but same similar type of logo.
It's a piece of a column.
Okay, part of a column.
Get it right.
it's going to be, if you see somebody using this, kind of where you provide your services. Where do you provide your services? State of Louisiana.
Right.
So if you see somebody else having the same logo and you can show that you've been using it longer than this other third party, competing party has been doing so, then you technically have common law rights that you can enforce against that. Or if they register theirs and they say, oh no, well, we have a registration on this, well, you can say, well, no, I've been using this since 2010. No, I have priority. I've been using it for 13 years. You've only been using it for 2. So now, if you wanted to try and enforce it against somebody where you're not geographically located and providing your services, well, then you're going to have a problem. So your rights in your mark, brand, logo, all of that, it ties to your use of it and your geographical location.
Interesting.
So especially like if you look at registration, you're only registered in the state. You can only enforce that in the state of Louisiana. If you don't have a federal registration, you're not going to be able to go enforce it in, let's say, Georgia, if you're not also using it in Georgia as well.
And to federally register it, I also have to prove that I'm doing things in those other states.
So you have to just prove that you're using it in commerce. You don't have to specifically show, okay, I'm in Georgia, Texas, Mississippi, New York, wherever. You don't have to prove that. You have to show some sort of, basically you're stating under oath when you fill out your application that you have been using it for a certain time period, and they kind of take you on your word for it. The only time it would really come into play is if somebody is trying to enforce it against you or trying to enforce their rights against you, and then they're like, well, no, he really wasn't using it that long, and then it kind of gets into a whole thing.
Here I am. I bring you on the podcast, and I'm trying to get some free legal advice, and I'm already going to have to buy 3 different services from you.
Yep.
I mean, this is
just racking up.
This is not registered.
And you don't have to register, but
if I want to prevent someone in Georgia using my logo.
So if you want to enforce your rights and give third parties a legal presumption that you own this mark, then that's why you want to register it. You already have ownership in it from your use, but to give other people and third parties that presumption that you do own it and to be able to enforce it, you need to register it.
So you and I, our sons play on the same baseball team, and we have to come up with our own name. So we go with Bandits.
The Bandits.
So I have a bright idea. I know what we're going to do. I go on Google. I look up a Bandits logo, the best looking minor league logo I could find, and I was shut down.
Well, so Chaz we have a team group me, and they're coming up with the name, and everyone wants to go with the Bandits. Oh, we need a logo. Let's get some shirts for the parents to wear and support the team. And Chaz sends in the group me, hey, look what I found online. This is the Bandits, the logo. I'm like, Chaz, we can't be stealing logos from other teams, in the country. Like, now is anyone going to enforce it against our little league team? Probably not. But
no, we have. But I mean, I'm pretty sure that there's little league teams everywhere that are stealing logos from
probably
different
so.
teams. But I mean, it would be a bad look that we have probably 5 lawyers.
5 lawyers on the team, and we've stolen a logo,
including an intellectual property lawyer.
No, I wouldn't allow that.
No. So when you, like, let's say I wanted to enforce my logo, someone's using my brand, I come up with let's use Sandy Lies as an example. Somebody starts selling Sandy Lies hats. What's my recourse? What do I do?
So generally the first step is sending, cease and desist letter to whoever that person is or company is. And you're going to say, we own this mark, we own, the rights to it, we've registered it, we've been using it since such and such date, you're in violation of our mark, and things like that. The majority of the time, when somebody receives one of those letters, they'll stop using it. Most of the time it's, unintentional and whatever it may be. Now, every now and then, you're going to get those that are like, absolutely not. We've been using this too. We think that yours is invalid for various reasons, and you don't properly own it, or there's a bunch of different, defenses. You could say it's too generic, which we can talk about that in a minute too. It's too generic, so it really shouldn't be registered anyways. So, but that's not as common for somebody to actually say, no, go ahead and sue me. So if that happens, though, if they do continue using it, then you would pursue, a legal action against them and file, a petition or something, depending on where you're registered. So if you only have a state registration, you would do it through state court. If you have a federal registration, you would do it through federal court.
Ouch. Mm-hmm. And you do that? Mm-hmm. That's fun.
Yeah, we had a recent one where it was only a state one because I only had a state registration. And so we filed suit on behalf of, this entity here in town. And, it ended up settling. But
it settled. Mm-hmm. Are there penalties or do you have to prove?
So most of the time what you're trying to achieve is an injunction. And so what that means is for them to stop using the mark. And so that's the most important part. You want them to cease using it. If you can show that there was bad faith, or sometimes, a court may award damages as well, but really the most important part is the injunction.
And do you have to go before a judge? Mm-hmm. Yeah.
Yeah. Well, unless it settles before then. Mm-hmm.
And do you enjoy litigation?
No. It's it's not my favorite. We'll do it, and I'll do it, but yeah, I would prefer not to. But I'm not going to, force somebody to settle if it's not in their best interest and the other party is not being, cooperative either. So,
do trademarks expire?
No. So, as long as you can show and prove that you are still using it, because again, it goes back to that use. You actually have to be using it to have your rights. Then essentially it doesn't expire. Now you may have some maintenance requirements. So at the state level, it does. It's a 10-year window, and then it does expire, but you can renew it. At the federal level, I want to say it's 5 and 8 years. I don't know. I got to look that up.
I'm going to hold you to this.
Yeah, I know. Don't hold me to the years. But there is a certain time frame in which you have to submit a declaration stating that you are continuing to use the mark in commerce, and so you haven't abandoned your rights.
My logo, if I change my logo and I don't do anything, it could potentially expire, and someone else can use my logo in the future.
Yeah. So there, it could be a case of where you've abandoned your mark. So with abandonment or non-use, it's arguably, up to somebody else to say like, oh, they're not using it anymore. So actually my partner was telling me the other day, because I was asking a question about a current client we have, and he was telling me about Mellow-Joy in comparison with Community Coffee, and I didn't know this story, and so if I don't get it correct, don't hold me to it either. So apparently Mellow-Joy years ago sold to Community Coffee, and when they sold, Community Coffee no longer didn't use Mellow-Joy, the name, the mark, the logo, any of that anymore. So somebody else, I guess years later, started using Mellow-Joy. They're like, oh, it's free. They sold it, or it's free to use. They sold it. They're not using it anymore. And apparently and then Community Coffee was like, no, we bought Mellow-Joy and all that. Well, it turned out that the guy was right. I mean, they technically abandoned it, even though they purchased it. Community Coffee purchased, the name Mellow-Joy. They had not continued to use it for a certain period of time, and the court found this guy could start up Mellow-Joy again and start using the name. So, you can't abandon your rights if you don't use it. And
if you don't use it, you lose it.
Pretty much.
And the idea of that is we want commerce to happen. We don't want to tie up names and trademarks and brands and all this stuff if people aren't actually going to use it.
Right, correct.
Because somebody may be able to make money with it.
Yeah, and so I always have people ask me, oh, I want to use this name, later on. Can I go ahead and register it? Well, no, and that's why, you can't prospectively try and hold it. You can try and reserve, a name at the state level for a little while, but in order to actually register it, you have to be using it. You can't say, oh, I'm going to use this 3 years down the road and just hold it. You can't do that either.
Are you familiar with what's going on with Taco Bell?
Yeah.
Yeah? So it's the name Taco Tuesday?
Taco Tuesday, yeah.
Well, can you tell me a little bit about that?
So apparently back in the 80s, this taco, restaurant out in Wyoming registered the phrase Taco Tuesday in association with their restaurant services that they provide. Well, if you haven't known, or if you're not aware, the phrase Taco Tuesday is pretty common now. So Taco Bell, a couple days ago, last week, filed a lawsuit claiming, trying to be a white knight on behalf of the people, stating that this phrase Taco Tuesday is too generic and needs to be liberated for everybody to be able to use now.
Thank you, Taco Bell.
Right, thank you, Taco Bell. We've all been waiting for this. But there is an interesting argument. Has that phrase become too generic to keep registered? So when you're registering a mark, you can't register something that's a generic term. So, if you're selling a bicycle, you can't register the word bicycle. That's a generic term. So has this phrase, Taco Tuesday, become too generic to have ownership rights in? I don't know. It's interesting. So they call it genericide. I mean, that's happened to other brands and names. What's a really common one is you think of Band-Aid. When you're reaching for, something, it's technically an adhesive, but people call it Band-Aid. Well, that's actually a name. That's a brand, Band-Aid. Same thing with Kleenex.
Xerox.
Mm-hmm.
So what the company should have done was actually enforce their trademark by doing certain actions to protect themselves.
So you have a duty to enforce. So if you have a registration over your brand name and your mark, you have a duty to enforce that. If you don't, then basically are you weakening your mark and making it and causing it to become too generic? So this Taco John's are claiming that they did enforce it. They've sent various cease and desist letters over the years. I don't know if that's true or not. Apparently they sent one in 2019 to some company, and so they said that they've just never had to go to litigation before. So are they really enforcing it? Now, can you actually enforce it across the country? I mean, when you have little mom and pops and,
LeBron James was
so LeBron James apparently attempted to register Taco Tuesday himself back in 2019 and was refused registration because it said it was too commonplace from what I read. So, what was he trying to register it for? Obviously not the same restaurant services that this Taco John's has, because you can't do it for the same type of goods, but it
was for Instagram clout.
For Instagram, yeah. So, but yes, you do have a duty to enforce it. Now, can you actually enforce it wholeheartedly across the country when everybody's using Taco Tuesday? I don't know. A lot of these big companies, they literally have people that are hired just to police their marks. One of the big ones and main ones is Disney. I mean, oh my gosh, they are very aggressive in protecting their marks. We had a client, I want to say in Karen Crow, and they were doing fun jumps with Disney characters, and they got a letter. So, they'll find you. Disney will.
I was always told you cannot find a bakery that will make a Disney cake.
And we had this was in Alabama, making cookies with the Alabama A and the Auburn, AU. If you don't know, I'm from Alabama, so that's why I know about it. But, you're going to get a letter. And the same thing, I mean, for a lot of these.
Do colleges pursue those aggressively?
I think the University of Alabama did in that instance with this bakery. And, another one, you think the Masters, with their very distinguished logo that they have.
And I wouldn't play with the Masters. No. I think they're
pretty.
I'd like to. I like to play at the Masters. I wouldn't like to play with them. I think they're pretty tough with their IP. Yeah. I mean, you can't find non-Masters gear for sale anywhere. Yeah, knockoffs.
You're gonna be hard pressed to find it.
You can't go on Alibaba and find Masters knockoff gear.
Now, whether you're at home stitching it yourself, or Beth's making it, with her Cricut in the back room, I don't know. But just
don't tell people my business, Sarah.
Don't show me. So.
How do you think we support this podcast? We make Cricut Masters gear. Taco Tuesday has a different connotation around our house. Do you remember this?
When the fire truck showed up down the street? Oh, yeah. So my kids love that.
My wife puts in taco shells in the oven. Taco shells are apparently very flammable. And you have
it doesn't take long to burn.
It doesn't take long to burn. Next thing you know, the smoke is pouring out the oven. And I look at my phone and I have 4 or 5 missed calls from the alarm company. And then I hear burp, burp, burp.
We looked out the window and we're like, oh my God.
I said, oh, shit. So the oven was off. That's all done. And then all of a sudden, 4 or 5 red engines show up to our house.
Yeah, our kids thought it was great.
The kids loved it.
They loved it.
The kids loved it. The firemen were very gracious with their time, very understanding, but forever, we don't do Taco Tuesday anymore at our house.
Just go out for those.
We just go out. We just go out to one of our local Mexican joints because that was not a good situation.
Yeah, no, I do remember that.
Very embarrassing.
Yeah.
And, of course, my wife goes, hide, and I look like the guy that's burned the taco shells, right? So, but I'm glad your kids enjoyed it.
Yeah, they did. They loved it. I mean, any excuse
entertainment
for a fire
provided
truck.
by the Roberts for the day.
We didn't want to be like those neighbors, peeking out the window. But
oh, no.
when you see fire trucks come down.
No, her two sons were in the back, hanging off the back with fireman's hat on. I mean, it was show and tell for the day.
Yeah, it was great.
Well, so Chaz, your Little League faux pas with branding, even though it was done in Little League, it also is done in the major leagues. I don't know if you saw this week, as of this recording date on May 18th, the USTPO denied the trademark application for the Washington Commanders. They cited the likelihood of confusion due to two other registrations. One is for the Commanders Classic, which is the college football game every year between Air Force and Army. And the other was just some dude in the D.C. area who sent in a bunch of applications for both the Washington Space Commanders and the Washington Wolf Commanders whenever they were going through all those name changes. So don't feel too bad. It's happening in the big leagues too.
Yeah, so I think what was happening there was some guys, they knew that Washington was looking for a name.
Pirates.
Yeah, is that what they're called, pirates?
Yeah, there's another term for them, but I forgot, but it's something pirate. Yeah,
they try to preemptively get every name.
Yeah, and then you have that with a lot with domain names too. You get people like, oh, I know that's going to come up, and it happened a lot with. Especially since the name, image, and likeness thing came up with college sports. People were out there taking domain names for all of these college kids.
And they jump. And a lot of these, if you really have your heart set on the name, they keep it basically hostage, hold it hostage, and you have to pay them whatever. Yeah,
and so with the Commanders, that's a good point. So when you go through registration, you may not be able to get registration because the USPTO, when you register something or attempt to register something, they're going to do their own kind of evaluation in their internal search for various names and logos and things like that too. And so what happened there is they said, oh, well, there was already something that was registered that was similar, the same or similar, and it would be deemed to be likely to cause confusion to a consumer. And so because of that, it's too similar, whether it's in sound, image, appearance, the way it looked, well, that's obviously image, things like that. But so it's going to cause a likelihood of confusion for the consumer. It's too similar, you can't register it. So they can kind of nip it in the bud right there and say, no, you can't register that. Or if it gets through for whatever reason, you'll have somebody say later on with a lawsuit or a cease and desist letter, oh, this is too similar. Maybe the USPTO missed it or whatever it may be. But so there's kind of two avenues to that. The USPTO can kind of preemptively say no, or if it gets through, then somebody can say, oh no, that's too similar to mine and here's a lawsuit.
Didn't the USPTO also, whenever they were still called the Washington Redskins, didn't they basically force the hand of them changing their name by removing their patent of that name?
So I don't know about that, but I do know you cannot trademark things that are inappropriate, certain bad words or things like that.
Retroactively
so maybe it was because of that. They deemed it inappropriate based on the connotation of the word redskin. That was probably what happened. I'm not familiar with it, but that would be my guess to it. You can't register, vile, vulgar language and other things that are discriminatory or, things like that too.
So one thing I notice is you see a lot of colleges going to throwback jerseys. Mm-hmm. Do they do that? I mean, I'm sure they probably sell a lot of gear when they do that and the players enjoy it, but is that a way of using their logo?
I don't know for certain, but it's easy to make that assumption. So, logos have kind of modernized over time. They change them up and all that, but they all have these throwback logos. I mean, I know you know of LSU's and, I went to Auburn, so I know of Auburn's, and then they do kind of bring them back periodically. And so it would make sense that the reason they do that is to continue their use of those so that, they haven't abandoned their rights to those logos and that sort of thing too.
And so how does an Auburn Tiger come smack dab into LSU UL region and kill it in intellectual property?
It is a very interesting story. I never thought I would be here. I never thought I would be in law, and I never ever thought I would be in Louisiana of all places too. So I went to Auburn as pre-med, graduated in biomedical science, and my whole life kind of intended to stay in the science and math route. That's always what I was good in. And towards the end of my senior year, I mean, I'd taken the MCAT, I had done all of that already. I had not technically applied to med school. That was the only thing I was waiting on. And I kind of thought about it. I'm like, I don't know if I want to do this. What am I doing? And I remember it was Christmas break, and I'm like, I have one semester left, and I'm like rethinking my whole life. And I was like, okay, well, too late now. I can't change my major at this point. I'm about to graduate. So I went ahead. I'm like, well, I'll just finish school. And I'll figure it out later. So went ahead and graduated, moved back home, got a summer job at a local country club working as a pro shop girl. That's where I met my husband. Go figure. And like literally thinking, what am I going to do with my life? With a biomedical science degree, what can I do? Really the only option was some sort of graduate degree or graduate program. Literally woke up one day and I laugh because I say that I had an Elle Woods moment. You know, if you know the movie Legally Blonde, and it was like, well, I'm going to go to law school. That's literally what happened to me. I woke up one day, I was like, I think I'll just apply to law school. I don't really know what else to do with my life. So applied, moved to Jackson, Mississippi, went to law school, and really while I was there, had no plans or intentions to go into patent law or intellectual property. I didn't know much about it. And then a family friend of my husband, who's my boyfriend at the time, but of his family, got to know me, and she's an attorney in Baton Rouge, and she brought me down to help. I was clerking down there at a large firm, and had dinner with her, and she said, I want you to meet my friend Jeannie, who is a patent attorney, and I think y'all would hit it off, and I think it would be great for you. So I met her, and we just started talking, and she kind of let me know about what patent law is and intellectual property and all of that. I ended up clerking for her for a little bit too, and realized like, okay, I think I can do this. And that was my second year of law school. So then graduated law school, moved here to Lafayette because that's where Ben was. He had started his business here in Lafayette, and again, never in my life moving to Jackson, Mississippi, then from there to Lafayette, Louisiana. Never anticipated that.
Welcome.
Yes, thank you. And so moved here, didn't have a job, looked online. I'm like, I need a job. So I had already taken the bar and didn't know my results yet, but found on the Lafayette Bar Association a job flyer for a patent attorney or intellectual property attorney. I'm like, well, I'm not one, but I'm just going to go ahead and apply anyways. And asking for like 3 years of experience, which I didn't have. And I applied, and lo and behold, they hired me. So, got hired, started working. In order to actually be a practicing patent attorney, you have to take a separate bar exam. It's the only type of law where you have to take a separate bar exam beyond just your normal state bar and then your ethics bar.
What is wrong with you?
I don't know. It's just overachiever, I guess.
I could not imagine sitting for another bar.
Newly married. And I'm like, well, I guess. And then, so in order to sit for it, you have to show that you have a science background. So that's where it kind of came into play. And again, never expected to do this in my life, but because of my undergrad background, it worked out. And so you have to have either an engineering or science background of some sort, or if you don't have a degree in it or majored in it, you have to like prove and show with your transcripts you had a certain number of hours.
Which is a unicorn in law school.
Oh, yeah.
Because most people have an arts background, English, poli-sci,
journalism,
pre-law. I had a business degree.
Yeah, like I said, I never in my life.
I think I took 2 science classes to get a business degree.
Just to check the box.
Right.
Never in my life in law or in undergrad or even after undergrad for a while thought I would ever be a lawyer, and then lo and behold, a patent attorney too. So all the stars kind of aligned and worked out.
That's amazing.
So yeah.
How many patent lawyers are there like around here or throughout the state? I think
if you can go on, the USPTO has like a database of them, and
I'm not going to do that.
You don't have to do that. I want to say registered patent attorneys in Lafayette, about 20 to 30, but that's all of them. So even if they're retired or even if they're not practicing, that also includes a patent agent, which is someone who's taken the patent bar, but they're not an attorney yet. You could do that too.
How many of those people are women?
Two.
Mm-hmm.
Two of us.
That's amazing.
Yeah. It's a very male-dominated field, especially here in South Louisiana. And the reason why, when you think about it, it's so oil and gas driven, which is by nature also a male-dominated field. Yeah, there are not a lot of females, and I've actually had women reach out to me. They found me somehow online or whatever it may be and say, I specifically want a female patent attorney or intellectual property attorney. And, they're just not as common. Now, I mean, there are some, and females in general, I think you're starting to see more in the legal field than you have before. But yeah, no, we're still a minority group. And there was one day I walked in, I had a client meeting, and new client, had not met yet, and only online communications. I walk in, thought I was the assistant. So I'm like, oh, I'm actually your attorney, but that's okay. So you still get some of that. And then I had an older gentleman kind of start, it was, another new client meeting, start asking me my qualifications and why I was in the room. I'm like, well, you came to see me, so I don't know if I need to give you my whole, resume and all of that too. But so you still see some of that. But I've been very fortunate to work with people who are very supportive, and where it's not an issue.
What advice do you have for women who are interested in becoming a patent attorney, or young ladies who are interested in becoming a patent attorney?
Do it. I mean, just do it. I think, I don't know.
Is there something they can do to prepare?
Well, I don't know if it's prepare. I don't want to say get a thick skin. I naturally have that. Not that you necessarily need it, but just know that, you are going into an area where there aren't a lot of you, and you just have to be confident in that and know that you know what you're doing, and just have faith in yourself and just believe in yourself. That's it.
That's awesome. And you said you have to have a science background, science or engineering background. So
to even sit for that bar exam, you have to submit that to the patent office and show that you meet those qualifications before they'll even let you take the exam.
Awesome. Well, next time you come on, we're going to talk all about inventions.
Yeah.
And we'll talk about my Shark Tank inventions. Yeah. And where can people find you?
I don't know. That's a good question. We don't have We don't have a big social media presence at our firm.
I promise you're going to have a better response. I'll let you think about this. You're going to have a better response than one of my guests, Benny, where he was basically like, he thought about it for a while. And he's like, just call Chaz.
Call Chaz.
He'll track me
link
down.
You up. Google me. I don't know. Maybe don't Google me. I don't know if I'm on Google. But we have a firm website, I think.
What's the name of your firm?
Babineau, Poche, Anthony, and Slavich. And I've been there since I've been practicing.
Awesome. What's the phone number?
337-984-2505 is our main line, and my direct line is 337-354-1787.
Awesome. Real quick, last question, real quick. Favorite law movie not named My Cousin Benny?
Which is a good one. Well, Legally Blonde. I told you, I had my Elle Woods moment. So I feel like, any millennial female that's an attorney is going to kind of gravitate to that movie. Just a classic. But
it is a classic. Yeah. I can't relate to it, but it's definitely one of the top.
It's inspiring. Is it, practical and a good reflection of real life? No, but, it's fun and lighthearted. So
thank you for being here, Sarah.
Yeah, thanks for having me.
Awesome. Hey, it would mean the world to me if you subscribe to the podcast and leave us a 5-star review. It helps keep the show free, and it helps us book better guests to provide more valuable content to you. None of the opinions expressed by my guests are that of my own, and nothing we talked about creates an attorney-client relationship or could be construed as legal advice. Hope you enjoy the show.